Welcome everybody. We're going to discuss Senate CIR Bill S744, what it means for employers, including the new mandatory e-verify provisions. This information, by the way, I finished this PowerPoint at about 5 o'clock this morning when I was reviewing the 850 pages of statute and the hundreds of changes that have been made, including specifically the Hatch amendments, which were made last week, and I was also trying to incorporate Darrell Issa's STEM amendments. Now, the important point to note about this immigration bill is that there will be substantial changes along the way. Number one, the bill is now being cleared and is off to the full Senate. However, we're going to see more changes in the Senate, and then it's going to go to the House, and then we're going to see more changes in the House. But I think the fundamental architecture of what we have is what we will be seeing. And generally speaking, my attitude is this is a good bill. It's been a long time since we've had immigration reform. This is the good old comprehensive immigration reform, but the impact on employers is very, very substantial. Both in terms of compliance and in terms of benefits available to obtain qualified workers. So with no further ado, we will move forward and talk about these many provisions. Now, I do caution you all, this PowerPoint presentation is much too long. I have almost 100 slides, and there's no ways I can cover it, so I will probably end up breaking it into two separate presentations. So if this is your first Wolfsdorf immigration webinar, please sign up to our newsletter at www.wolfsdorf.com. These are free webinars, and you will be learning all about the new immigration laws, the old immigration laws, and every other topic I can think of. So please encourage your friends to join. Just little technical snafu here. Just got to advance my slides, and there we go. That worked. So the critical information that we need is that on May 21 last week, the Senate Judiciary wrapped up weeks of work. We saw the Senate working. This was really impressive. The so-called Gang of Eight. Getting together and passing the Border Security, Economic Opportunity, and Immigration Modernization Act. Is this Bessie Omer? Is this Bessie May? Which one are we going with? Choose your own name. The bottom line is that it passed out of the Judiciary Subcommittee on a bipartisan vote. Yes, a bipartisan vote. And Senator Harry Reid has vowed to bring it up quickly. We actually expect the bill to come up probably by the end of next month, and we do expect the Senate to pass it. So what exactly is this all about? Well, there is a lot that will impact employers, including the mandatory e-verify provisions, Section 301 to 3204. This includes participant impact requirements, and by the way, I will be doing another webinar with Law Logics, so you can Google Law Logics. That will be on June the 4th, which will deal exclusively with this specific aspect, which is the mandatory e-verify provisions, and also the new civil penalties for unauthorized aliens and for record-keeping violations. Now, word of warning, these penalties are rather steep, considerably more steep than what we have at the present time. Moreover, we are going to be in a very, very rigid enforcement mode. We have seen the agencies becoming extremely aggressive in terms of enforcing I-9 violations. Basically, what we envisage happening is that Congress will pass a law that will give undocumented the right to obtain lawful status over a period of time, but we're also going to see massive enforcement against employers. As usual, the framework is going to be, we're going to remove the lure of jobs. Now, there are certain concerns. There are concerns about agriculture, there are concerns about landscaping, there are concerns about construction and various elderly care, minor care, all those domestics working in your households, working, doing the gardens. Do we have liability for them? Well, the answer is, I think people know what the answer is. If you knowingly hire an undocumented alien, you have liability. So this is the time to clean up your act. This is going to be the time to get legal, and moving forward, it's going to be very difficult for people who wish to hire people who are not authorized to be employed in the United States. This law has got teeth. This law is very significant, but it will provide a roadmap to legal status for those most of those people who are undocumented. Of course, there will be exceptions for people with criminal convictions and people who do not meet all the requirements in terms of unlawful presence. Okay, so what exactly has happened here? One of the good pieces of news is that the H-1B quota has been expanded. The current cap of 65,000 is increased to a floor of 115,000. That is pretty much double the number of H-1Bs. As you all know, we literally ran out of H-1Bs in about 1 day. Yes, 1 day, because you had to get them in on the initial day of filing. And within a week or so, and the hit rate on H-1Bs for bachelor's degree was probably about 50%. So more than 50% of those H's didn't go through. It was a little bit better with the master's degree category. Most of probably the hit rate on those was about 70–80% of those were accepted. But it was a disastrous H-1B season, and this year we're going to see a substantial improvement if this bill goes through. At the same time, there's quite a few restrictions on the H-1B quota. So the expanded base may go up and down by as many as 20,000 each year, but will not exceed 200,000, and that will be determined based on H-1B visa demand by employers each year. So increase or decrease is going to be demand-based and can go up to 200,000, but not more than 20,000 at a time. Now, this presentation is broken up into two, actually more than two, but two basic frameworks. The first is the expanded opportunities for hiring, worker hiring, and retention. Talking now about immigrant visas. And the situation with regard to immigrant visas is, quite frankly, atrocious. I love to use the example of somebody who has a master's degree from Stanford in computer science, happens to be born in India. That person could be stuck in an 8 to 10 year waiting line. Come from China, 5 to 6 year waiting line under the current system. If this bill doesn't pass, these folks, these highly technical, well-qualified, critical employees are going to have to languish for 5 to 10 years to get a green card, even with a master's degree. And please don't even raise the question of what happens if they only have a bachelor's degree, because the waiting lines are even longer. Now, it's 1990 is the last time Congress amended or looked at these ridiculous waiting lines. That is 1990, 23 years, folks. Where have we been in the last 2.5 decades? Absolutely no improvement. So the bottom line of what we have here and how this statute is going to work is that spouses and children of immediate relatives are basically going to be exempt. They're basically going to be exempt from the quotas. The number of people who are spouses of permanent residents, the current F2A category, is very, very substantial. So this will remove a lot of people from the family and from the employment waiting lines. Priority workers, individuals of extraordinary ability, outstanding researchers, professors, multinational executives and managers. That category currently runs at about 40,000. Certain doctors, healthcare professionals, and graduates with U.S. advanced degrees in science, technology, engineering, or math that have a job offer in a related field, and these folks are potentially going to be able to avoid the ridiculous waiting lines that we currently have. So we're looking at a group of well-deserved folks spouses and children of U.S. citizens and permanent residents, priority workers, certain medical doctors, healthcare, and U.S. advanced degree, master's and above STEM graduates are going to find themselves in a wonderful position under the new law, and I have to say, should the law in fact pass. In addition, the annual per country quotas, and this is particularly going to benefit people from China and India. I think it's the old HR 3012 that was unfortunately stalled in the Senate, and other oversubscribed countries are currently waiting up to 20 years to immigrate. These per-country quotas are now removed, and more than this, another 55,000 immigrant visas would also be available. Sadly, the DV lottery is abolished. Some people will criticize me for using the word sadly, that the DV lottery is abolished, but the good thing about the lottery is that it gives hope to people who otherwise wouldn't have a chance. I know that the argument against letting in these highly technical and sophisticated people is not that strong, but at the same time, as much as people love to criticize America, we find millions and millions of applicants every year from all over the world lining up to participate in the DV lottery. This program is good for America. This program is good for America. It reminds the world exactly how desirable America is. This is, in my opinion, the greatest place in the world to live, and the lottery shows that. People are clamoring to get in here, and it gives hope to those few people who may not be of extraordinary ability or outstanding researchers or medical doctors or U.S. advanced degree. I recognize the right to choose and select the most qualified, but I also believe that America is a country that also gave opportunity and hope to people all around the world, and that's what the DV lottery does. So please excuse my little plug for the DV lottery. It also provides visas to those people who have not been successful in the U.S. immigration race. So as a result, this DV lottery has allowed thousands and thousands of people to immigrate from all walks of life. The requirement is you do have to have a high school diploma or some higher education, so it's not exactly like we're letting in the true refugees. So there's my little plug for the DV program. Okay, so we also have a new merit-based immigration system. This is all falling under the category of expanded opportunities for worker hiring and retention, and we now have our new merit-based point system with up to 120,000 green cards. Now, to be direct, I have criticized the merit-based system in the past. Do we really need more PhD cab drivers in Los Angeles? The answer is we don't need more PhD cab drivers. So I have some questions with regard to the merit-based system, but you know, my views aren't that important. The views of Congress are far more important, and it looks like this system has a very high possibility of being enacted, up to 120,000 green cards. Folks, that's a lot of green cards. Just so you know, the current employment-based system provides 140,000 green cards. That is, the entire current system is 140,000. We're going to add 120,000 based on a variety of positive attributes. And what are these? They are education, work experience, family ties, letting in the younger people. I've got no chance. Hey, by the way, I'm a naturalized citizen, and I love to say this, a proud naturalized citizen. I digress a moment just for a little bit of humor's sake, but I was at the supermarket yesterday, and I saw the American flags, and I said, you know what? I need one of these on my gatepost too. I don't know what it is, but this is an amazing country. I must say how fortunate I am to have immigrated almost 30 years ago and to live in this wonderful country. And what we're talking about now is America's tradition, a nation of immigrants, welcoming immigrants again, the post 9/11 saga where basically America took up what I'm going to call a new approach to immigration, restrictive and somewhat negative, is hopefully going by the wayside. Why did this all happen? Well, you know, President Obama did something very, very, and let's use the word smart. just a few months before the election, he decided to enact the DACA program. That was basically, and I'm going to use the A word, amnesty, opportunity for kids who are undocumented. It was a chance for them to get right with the law, get legal, get work authorization. As a result of that, President Obama picked up the Latino vote, picked up some of the Asian vote, won the swing states, and the Republican have now realized that being anti-immigrant is not a good way to win elections. In fact, it may make the Republican Party a permanent minority. This is the reason why we now see Republicans embracing immigration, and those restrictionists have been told to, shut up in a nutshell. Of course, we will see a lot of restrictionist noise. There is, I should use the word chatter, but to me it's noise. And the bottom line is I do think we're going to see some new legislation this year. Is this legislation going to be good? Yes. Is this legislation going to provide good opportunities to employers? Yes. Is this legislation going to remove some of the ridiculous waiting lines? Yes. Is this legislation going to allow employers to bring in people with talent? Yes. Is this legislation going to make it easy for employers? No. Why is that? Well, the new framework is one of extreme rigor. The new framework in terms of hiring undocumented is going to be, should I use the word foolproof? With E-Verify, of course, the potential exists that we're going to see a lot of identity theft. We're going to see more identity theft than you've ever seen. And there's one thing that just freaks Americans out, freaks me out, freaks everybody out. And by the way, I'm an American, or at least a dual citizen. That other funny, phony English accent that I have, that's a South African accent. So I'm a dual American South African citizen. And I like adding the word proud, dual American South African citizen. So moving forward here, let's go into some of the other aspects of this new legislation. The privilege of visa revalidation. Those of you who are old enough, up till a couple of years ago, was possible to get a second visa by sending your passport to the State Department for reissuance. This was stopped, as presumably as a security measure. But the nice thing is that all of these categories, A, diplomats, E, investors, G, government, interbank, etc., employees, H, I, L, N, NATO visas, O, extraordinary visas, P, performing arts, etc., religious workers, and the new W category. Wow, is that the Wolfsdorf category? The new W category will be able to get new visas by mailing their passports to Washington and getting it back in the mail. Oh, we love visa revalidation, everybody. The headache of having to send people abroad to get new visas and be stuck for months is just terrible. However, no guarantee. This is only for low-risk applicants. They're going to have to be able to pass a background check and subject to the authority of consular officers to require an in-person interview. So we're going to see certain categories of people subjected to additional security. That was always the case. Security checks, you know what? They are a pain. But as we are constantly reminded, particularly by the sad, tragic events of Boston. I say this, I ran the Boston Marathon 3 times, and I know that spot on Boylston very, very, very closely and dearly. And boy, I can just say whatever needs to be done to stop these terrorists needs to be done. And one of the things that's going to have to be done is continued security checks. How do you spot the bad guys? And of course, in that instance, they did actually have information. Bernie, do not digress, but I do need to tie together what we call visa convenience and security checks and understand we are a nation at war and security checks are wholly appropriate and necessary in terms of weeding out the bad guys, and spotting a bad guy, quite frankly, is just not that easy. So that's what we're going to see in the visa revalidation program. And I just saw a little typo there. Please excuse my typo. This was finished at 4 o'clock in the morning. So we'll have to fix those up before we post this. Expanded opportunities for worker hiring and retention, the 240-day rule expanded, and the new W visa. Now, what is the 240-day rule? You know, every time we have to file an extension, we do have a great calendar system. We have this very expensive system which provides all the bells and whistles. But for some reason, it still often happens that the employer, the foreign national or somebody or travel leaves the extension of the visa to the last minute. And the good news is that people in these categories, A, diplomats, E, investors, we've been through this list already, H1 workers, presumably that's H2, 3, I, journalists, J, exchange visitors, L, company transfers, O, extraordinary, P, performing artists, etc., musicians, Q, culturally unique, R, religious workers, and the TN category, which is Canada and Treaty NAFTA visa categories, Canada, Mexico, assume that'll include Singapore and a few others, Chile. The good news with these folks is that you will be able to file your extension 2 days before and automatically get 240 days of employment authorization while the application is pending. So isn't that just glorious? We currently have that on some other categories. We currently have that in the H context and the L context, but it's going to be expanded. So this is the good news with the 240-day rule. Now, what about the new W, non-immigrant visa? I'm going to call that the Wolfstorf visa. Come on, Bernie, stop being completely silly. Well, you know what? It is a long weekend, and the first day after the long weekend, I'm surprised we had over 200 people registered for the program, and with very little last-minute notice. So that's not too bad. What are we going to have here? Between 20 and 200,000 workers? Well, the simple bottom line is that the W visa holders will be granted admission for 3 years and allowed to extend status for 3 more years, a total of 6 years. This is for unskilled and lesser skilled workers. Why? Why are we doing this? Why are we letting in up to 200,000? I have a 25-year-old son. Why can't he go out and pick strawberries? I do not understand why he does not milk cows, why he does not pick strawberries, why he does not sit in the 120-degree sweltering Central Valley bending over all day doing agricultural work. I do not understand why my children will not do this work. U.S. citizens, I don't know. I think they prefer video games or something like that. Xbox games, is that the latest one we're playing? Boy, I age myself. Anyway, simple bottom line is that if we don't bring these folks in, the strawberries are not going to get picked. There's going to be a shortage of agricultural labor. This is well established, so this will provide an opportunity to bring in skilled, unskilled, and lesser skilled workers. Now, what about this one? Spouses and working age minor children of these folks will also be able to apply for. So we're going to have father, mother, and a grown-up kid, potentially 19-year-old, all working, picking strawberries. We've got the whole family out there picking strawberries. Well, that's good. I think that's good. We need strawberry pickers. Alternatively, we could just shut down food production in the United States, this great agricultural nation. We could just shut it down and import all our food from South America. Is that where we're going? Well, under the new law, the estimates are that 70 to 80% of agricultural workers in the United States, at least in the Central Valley, may be undocumented. 70 to 80% of agricultural workers undocumented, and the fines for employers are going to be outrageous. So if we do not provide agricultural labor, we will not have food to eat. Yes. When you go to Costco next time, there will be no lettuce, or if there is lettuce, expect that lettuce to be 5 times more expensive because we're going to have to import that lettuce. Maybe it won't be that expensive if we import it. May not be very fresh. Simple bottom line, folks, is that the undocumented labor source, the 11 million who are in the United States are going to get legal. They're going to have an opportunity to obtain lawful status, and let me tell you, many of them are going to move on. Many of them are going to move on and up, and they've had enough of picking strawberries for the last 15 years without any path to lawful status. We're also going to have a newly created independent agency By the way, I'm just going to remind listeners, this is a bill that has come out of committee. It is going to the full Senate. We're going to see a lot of changes on the Senate floor. And when the Senate passes this bill, which I believe it will, it's then going to go to the House. And the House is going to shred it up. And they're going to add more restrictions. A lot of the Republicans are going to say, we need more border security, put more policemen on the border, more policemen, more drones, more fences, higher fences, taller fences. And what I always say about a 50-foot fence is every time you have a 50-foot fence, remember you have a 51-foot ladder. So you have a 50-foot electrified fence. Then you have a 51-foot electrified fence. Scratch that. You have a 51-foot ladder, which allows them to get over an electrified fence. There isn't a fence that hasn't been built. Oh, well, there was a Maginot Line there. Let's think about that one, the Maginot Line. And then let's go to China, the Great Wall of China. That really worked well too, didn't it? You know, these walls and these fences don't work. So what is the government going to do? They're going to make you, the employer, responsible for hiring undocumented, and they are going to put massive penalties. So now is the time to get your immigration, Bernie, how come you've lost your words? Is to get your Immigration Act in order. It's time to get your I-9s in order, which, by the way, is the second part of this webinar. I do encourage you all to go to my website, www.wolfsdorf.com. All of our webinars are recorded and available. There they are. They're online. Listen to them at your leisure. When you need a laugh, just click on and you're going to hear Bernie getting carried away and enthusiastic as he normally is. Has a lot of fun. By the way, I have to do a shout out to my tech guy, Tao Ren. Tao sitting here in front of me. He's the genius that makes this all work. He got the PowerPoint 3 minutes before tea time, and he made it happen. So we also have this newly created Bureau of Immigration and Labor Market Research, whose job it is to identify shortage occupations. Well, folks, you know, I do have to say this is a really, really good idea, because what is the point of having an immigration system that doesn't identify those areas where there are labor shortages, and we can accordingly adjust the need for labor depending on actual real live shortages. This is the way it's done in many other countries. This is not the way it's currently done in the United States. So bravo on that one. And we see incredibly positive changes from the 240-day rule to potentially admitting up to 200,000 workers instead of the ridiculous H-2B system that we have. We currently have an H-2A system and an H-2B system. I say that's the equivalent of having all your teeth knocked out and screwed back in. Every time somebody wants me to do an H-2A or H-2B, well, we do say yes. I never turn cases away. But, well, that's not true. We do turn cases away. I never turn cases away that we think we can win. So the bottom line is that horrible H-2A and H-2B system will go, and we're going to have the new W system, the new W non-immigrant visa, named after yours truly. Come on, Bernie. Okay, what else do we have? Well, there's a whole lot of other things, and it's amazing, 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 amazing. I had my very smart associate, Joseph Shepard, do an update to incorporate some of the Hatch amendments, which just came through last week. And now he's starting to use acronyms. Some of them I don't even know what they are. New work visa benefits granted to citizens of Ireland. Well, the Irish do good. And, you know, even after the passing of the late Ted Kennedy, who was the architect of so much immigration law, the Irish are still doing okay. And South Korea also doing pretty good. And countries with U.S. free trade agreements, and some of the Caribbean countries, they are going to obtain specific benefit. Free trade agreement countries are going to receive specific benefits. So the Irish citizens will be included with the Australians under the E3 visa category. I love the E3 category. Those of you who haven't heard of it, it's very much like an H-1B, but so much easier. You just go to the American consulate, apply for your E3 visa. Your spouse can get work authorizations. So this is for countries that have entered into free trade agreements with the United States, other than Chile, Singapore, or Australia. Both of those, all of those countries currently will have, or currently do have, treaty NAFTA visas. Scratch that. Those are not treaty NAFTA visas, not North American Free Trade Agreement. It's just Free Trade Agreement, FTAs. And they are going to receive the new E4 visa. E for Edward, 4 visa, while South Africans deserve a break. Unfortunately, it's South Koreans. The South Korean citizens are going to receive E5s. That is E5s, and then the certain Caribbean countries, and they're going to be eligible for E6 visas. More to follow on the E6. The bottom line is that these folks generally will need at least an associate's degree, that is a 2-year professional degree. Under the current E3 category, the anticipation for most of the categories is that they will, and they do have to have a 4-year degree, 4-year bachelor's degree, but we have a softening of the standards here. All of these categories are available only if the intending employer files a labor condition application. With labor condition application, is it a labor condition attestation? We're probably going to see some more restrictions coming with the Department of Labor attestation. Currently, it's a minor review. We may see that there's going to be some substantial changes here. The big change with regard to the E categories, and it's not really a big change because spouses can currently apply for work authorization. This provides enormous opportunities. Spouse goes and gets a job. Husband may be free to have free market employment, open market employment authorization for E3, E4, and E5s. This is good stuff, folks. Let's move on. So what do we have? Deference for H&L extensions. A little bit of a typo. This was done at 5 o'clock this morning. Deference. What is deference? Here's what deference is. Actually, it's not a typo. It's correct. It's just that I continued the slide on the next page. But here's the simple bottom line, is that H's and L's, you file these things, you file an extension, and then suddenly the case is denied. So they are going to give deference to the prior approval, but then you go and read the fine print. Unless there's been a substantial change, not a change, a substantial change, or new material information, or if the agency decides in its discretion that it should not be approved. Oh, wait a second. You just said something and took it all away again. Okay? You just said something and took it all away. This is not right. This is not even funny. So you can get an extension approved unless we don't want to, is what it really says. Nevertheless, there is a message out here that there has to be a substantial change, but presumably there's going to have to be a reason. The government's always going to find a reason. The main reason I see is we made a mistake by approving it in the first place. That's my favorite one. You take them two applications, identical, one's approved, one's denied. Don't ever tell them about the ones that's been approved because they're going to revoke it and say that was a mistake, and it was a mistake to approve it in the first place. Blah, blah, blah. I don't know what happened to the rest of my slide, but the bottom line is that somebody just doctored my slide and pulled half of it out. The second part of the slide here, which needs to go back in, is that L1s who file for a green card 365 days prior to the expiration of the L are entitled to get an extension. This is like the H-1B. Maybe it's been removed. I had JJ look at it. Maybe it was removed by the Hatch Amendment. So this is what's happening. This is such fast-moving stuff. Thank you to Joseph Shepard for editing this for me to incorporate the Hatch Amendment changes, which were just made last week. So this is a living document. There was a proposal to allow Ls to extend beyond the 5 or 7 year limit if, in fact, they had applied for a green card 365 days prior and had a perm or immigrant visa application pending for at least 1 year. Apparently that's gone out, so we have to change the heading. And now, folks, on to the big one, RPI. What is RPI? Registered Provisional Immigrant Status. Yippee! If you've been sitting in the United States without unlawful status and you've been living here and you were unlawful, if they prove that they were in the United States from December 31, 2011, if they were in the United States on December 31, 2011 and April 17, 2013. So they have to prove that they were in the United States between December 31, 2011 and April 17, 2013 and satisfy a variety of conditions, including what? Payment of fines, payment of back taxes, payment of fines, payment of back taxes. So undocumented immigrants. Undocumented. What's the other word? Illegal aliens. Ooh, yucky. Where do they come up with that phrase? Undocumented immigrants will be allowed to adjust status to registered provisional immigrant RPI and will be granted employment authorization if they can prove they were in the United States on December 31, 2011 and again on April 17, 2013. How many? 10 million? 11 million? This is a lot of people. And they have to prove that they were in the United States during this period. And they're going to have to prove that they were in the United States in unlawful status. So they had to be in unlawful status. Here's the situation. This always happens. It's kind of a little bit awful. The legal guys, nope. The undocumented guys, yep. So, you know, it's not always fair, but there's no other way to do it. And these folks are going to be eligible if they pay a fine and they pay back taxes, show that they've paid up all their taxes, show that they've been in the United States, they're going to be able to get registered provisional immigrant status. Now, the talk is it's going to take 10, maybe 15 years before they're going to be eligible for citizenship. We don't even know if they will be eligible for citizenship, but I think that they will. And we're talking about millions and millions of folks. Folks, this is a good thing. Many of these people have been in the United States for a long, long time. The last time Ronnie Reagan passed an amnesty bill, folks had to show that they were in unlawful status from 1/1/81. Did I say 1/1/81? I'm losing track of the dates, but whatever I know is it's over 20 years at this point. It's a long, long time. Boy, let's do your math. It's nearly 30 years. Am I getting old? I remember when I started practicing law, I was doing a lot of the old amnesty cases, Immigration Reform and Control Act of 1986. That's a long way back. But simple bottom line is that if they were out of status from 1/1, can't even remember my dates. I'm losing my mind. But the bottom line is that people had to be out of status for a period of approximately 5 years, and they could apply for amnesty under the Immigration Reform and Control Act of 1986. That also brought in, for the first time, employer sanctions, and that also made it unlawful to hire somebody without employment authorization. Prior to that time, there was no such requirement. So an employer who knows that one of its employees has applied or will apply for the new RPI status after the program begins will not be in violation of the provisions of the Immigration Reform and Control Act for prohibiting the knowing employment of an unauthorized worker. What does that mean in real times? Look, you have this undocumented person. That person comes to you and says, I need a letter verifying my employment. So you provide a letter to that foreign national. You now know that that person is not authorized to be employed. So what do? You get fined? You fire the person? Well, no. There's protection for the employer if that undocumented comes to you. At the moment, we have this horrible situation. Hear no evil, see no evil. If the undocumented comes to you and asks for sponsorship, you know you will now have actual knowledge, not even constructive knowledge. You have active knowledge, actual knowledge, that is actual knowledge that that person is not authorized to be employed. Otherwise, why would they come to you and ask for sponsorship? So it creates a catch-22 under the current system. This new proposal removes that. Okay, so what else do we have? Mandatory E-Verify. Now, I do a separate program called E-Verify or E-Scarify. Which one is it? Well, should we be afraid of E-Verify? Look, the reality is that the majority of people are using the program, oh gosh, I hate saying this, seem to be pretty satisfied. I've been criticizing E-Verify for years. I've been writing articles like E-Verify, it's not ready for prime time. I've been talking about married women who do not go to the Social Security office and change their name, coming up as tentative non-confirmation hits. Oh, pooey, pooey, pooey. You know, it's been a problem, and it encourages identity theft. But this is the steam train that cannot be stopped. Repeat, this is the steam train that cannot be stopped. Every employer, repeat, every employer. How many employers do we have? We have about 6 million employers in the United States. And over a phased-in period, this is going to be required. Any person or entity that hires, employs, recruits, or refers for a fee, oh, closing down all those little loopholes, all those little job shops. Oh my gosh. For employment in the United States that is not casual, sporadic, irregular, or intermittent. Okay, you got away with the babysitter. You do not have to do E-Verify for your babysitter. But wait a second. What if she babysits 5 nights a week? Uh-oh, you better verify that babysitter. She better be over age or you're breaking the law. Irregular? Yeah, well, it's not irregular. Intermittent? It's not intermittent. She babysits 3 nights a week, 4 nights a week. Sporadic? Casual? 4 nights a week? You know what? I would say 5 nights a week. You better E-Verify that babysitter who's coming in. You better E-Verify that gardener. Are you going to get around using the independent contractor provision? Really? We'll see about that. I think this law is designed to close the loopholes. And mandatory E-Verify is mandatory E-Scarify if you do not follow the rules. So folks, now is the time to get your act together. You better get ready. Get your I-9s in order. Get familiar with and get a legal workforce. We're going to have an opportunity to make your workforce legal. And this is going to be, in my opinion, a good law, although I'm opposed to mandatory E-Verify. It's just that nobody else is. The president's in support, the R support it, the D support it. There's only one lone opponent, Bernard P. Wolfstorff. Why do we put the P in there? Just go with Bernard Wolfstorff opposing E-Verify, and a few other entities are opposed to it. I just think the idea of creating this mandatory system puts too much burden on the employer, too much burden on the foreign national. Don't repeat this, folks, but somebody told me there's $24 trillion of liability out there. Can we repeat that number? $24 trillion of liability. I didn't get this from research. I got this from gossip. Do I believe it? I don't even know how many zeros there are in 24 trillion, to be honest with you. But what I do know is of the 6 million employers in the United States, I'm going to take a wild guess. 3 or 4 million of them are in violation of the law. 3 or 4 million people are violating this law. So let's pass a law where pretty much every employer is breaking the law. Not by knowingly hiring an undocumented alien. I love the word alien. Not by knowingly hiring, and that's not a person from outer space. Sorry, I just saw Star Trek with my 9-year-old. Are those guys going to be able to be E-Verified? All right, Bernie, stop being weird, okay? Star Trek, Klingons. How do you E-Verify a Klingon? Did I pronounce it right? They look pretty scary, those Klingons. But Captain Spock is going to find a, was it Captain Spock? No, it wasn't Captain Spock. Great movie, by the way. My 9-year-old loved it and brought back my youth. Don't want to say how long ago that one is. But the simple bottom line is we've got some issues here. So I'm going to repeat this twice. It's in 2 parts of my presentation. Got to check employment eligibility under the E-Verify system. Employers in industries involving critical infrastructure, that's airports, etc., have 1 year to check the employment eligibility of all current, ooh, ouch, all current, 1 year to check current employees, ouch, within 1 year of the regulations are issued. By the way, last time it took them about a year to issue regulations. And new employees upon receiving 90 days notice. Ouch. Ports, airports,
sensitive installations, get your act together. You should already, because they're already being targeted. Large employers, those with 5,000 personnel, must enroll within 2 years. Got a little bit of time, not much. Goes fast when you're having fun. Mid-size employees, more than 500, you have 3 years, and all other employees are given 4 years to check. So quite a lot of time for the smaller guys, but, you know, time flies when you're having fun. So get your act together now is the message. We'll probably do another I-9. By the way, on April the 19th, if you go and check my webinar, it's online, April 19. Really good webinar, if I say so myself. Has got everything you need to know. You don't even need to listen to my next one. It's already recorded. Just go onto my website, www.wolfsdorf.com, free webinars, and you will see the recorded I-9, which was April the 9th, that addresses all these issues with regard to getting your act together. So let's summarize nice and quickly. Effective date. Federal government employees have to participate as of the date of enactment, this year, which, you know, that's the reality. Federal contractors, well, that's already required. Under the FAR regulations, that is already required. Critical infrastructure, 1 year. And there's our nice little cheat sheet. Employers, 500 plus, not later than 2 years after reg. 500, did I say 500? 5,000 plus, not later than 2 years after regs published. 500 plus, not later than 3 years. Agriculture, we've got 4 years, after which stop eating strawberries. No strawberries for us. Or lettuce. No lettuce, sorry. They will have the W-2 visa, which will provide agricultural workers. All employers, not later than 4 years after the regs are published. All employers, including you and your babysitter, if not irregular or sporadic. Tribal government, there we go. We're after the tribal governments, not later than 5 years. Going to have to comply with E-Verify. Immigration law violators, DHS may order employers to comply. So for those people who violated the law, they can just order you to comply with E-Verify right now. Voluntary participants, okay to do so. Voluntary before the deadlines, well, yeah, we know that. And states will be preempted. Hurrah! 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 You know, we have this ridiculous patchwork. I actually have it in one of my future slides. Maybe I should go and find it. You know, if it's only old people will know this, but, you know, if it's Tuesday, it must be in Belgium. If it's Wednesday, you must be in Arizona. If it's Thursday, you must be in Georgia. I mean, we have such a crazy patchwork of E-Verify laws for big multinational companies, different states, different cities, different requirements. The bottom line is we're going to have one federal law. This is the way it needs to be, except I don't like E-Verify. Hey, I'm running out of time, so you know what? I'm probably just going to fly through some of these. Good faith, de minimis, or inadvertent errors. Are we going to be okay? We'll see. We'll see. We'll see when they publish the regs. Under the present situation, we do have what I call the Sonny Bono Amendment. You know, I just had a case with over 300 people. We ended up with a warning only, and oh my gosh, we had to update and correct some hundreds of I-9s, which we did. We did, and we got a warning, no fine. Is that going to be possible? Yes. So inadvertent failures may be acceptable. Fines for hiring or continuing to hire between 35 and 75 per unauthorized alien. Let's work on that. We've got 100 people at $7,500 a pop. We have some serious money here. That's almost $1 million. Ouch! $500,000, $1 million. If previously fined, it goes to 5 to 15. That's about $1 million for the 100. Wow, we're going up. If previously fined and the individual is unauthorized, 10 to 25,000. 25,000 a pop times 100. Oh my gosh, I'm not good with numbers. We're now on $2.5 million of fines, and DHS can even enhance the penalties. That generally depends on whether you're large and whether you're a violator, blah, 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 the so-called various triggered triggers that increase the penalties. Record-keeping violations. Ouch. I didn't know that I have to fill out an I-9. Oh, I love that one. I didn't know that I have to complete the E-Verify system, so we just don't bother, as a lot of employers do at the moment. 500 to 2,000 per violation. So we're getting into some hundreds of thousands of dollars of fines. All this money going to DHS. Oh my gosh, these guys are going to get rich. Paperwork violations, 4,000 a pop. Did I read that right? Subsequent occurrences after 2, 8,000 a pop for paperwork violations. Oh my gosh, you are not going to win. 100 employees, 8,000, 800,000, $1 million bucks. Ay, 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 ay. This is not something you're going to win. So what about use of the E-Verify system? Well, you cannot use this to pre-screen job applicants. Repeat, you cannot use this to pre-screen job applicants. This is not a screening tool. Re-verification within 3 days after the last date of employment. That is a good update under the current system. You have to re-verify prior to expiration. So this gives you 3 days afterwards, the 3-day rule, the so-called Thursday rule. So if Monday expired, you're allowed to go to Thursday. Requires DHS to notify individuals whenever a query was processed for that individual. Oh, we have a little bit of civil rights there. That sounds good. Protection from liability. Employer shielded if good faith reliance on the system. Nice, 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 nice. And I'm talking to employers right now. You know, you try and do the right thing. You know, under the current system, the goody two-shoes gets into trouble. Repeat. Under the current system, the goody two-shoes gets into trouble. The more diligent you are, the more trouble you get into. The more you inquire. Please do not ask, Bernie Wolfstorff, I love your little South African accent. By the way, can I see your green card? Bingo, we got ya. You're trying to be diligent? You think because I have a funny, fake English accent, you can ask me for a green card? Folks, that's discrimination. I'm an American. I'll talk with my southern accent. That's my southern African accent. Bernie, don't do accents. It's not funny, okay? But I'm allowed to do my southern accent. I'm from the deep south of Africa, and that's how we talk in the deep south of Africa. We have our little South African accent. We pronounce our words rather clearly. Okay, requires DHS to notify individuals whenever a query was processed. Protection from liability, that's a good one, folks. Appeals process for aggrieved individuals. Wow, this is great. So people who are treated poorly can actually move forward. Administrative procedures, review by an ALJ, administrative law judge, keep the judges busy. Creates an Office of Small Business and Employee Advocate to assist with E-Verify questions. This is the L. Franken provision. Yes, Mr. L. Franken of Saturday Night Live, Minnesota Senator, has created an Office of Small Business and Employee Advocate to assist with E-Verify questions. Go on, L. We love you. Provides for additional assistance with employees experiencing hardship during the employment eligibility process. Go, L. Go, L. We like L. Franken. Oh, my gosh, he's funny. Did you ever read his book? His amendments are good. Okay, so what do we need here? There are certain record security programs, requirements for third-party vendors. They have to make sure. We've had some programs out there that are absolutely horrible, that don't work. We have funding to deter document fraud, $1 billion to stop document fraud. That's going to really work. You know what? They're already selling fake green cards downtown on Alvarado Street for $100. So you know what? Give me a break. You can put as many cops on the street as you want. They're going to be making as many fake green cards as you've ever seen. They're going to be knocking off those fake green cards. Is it going to get you through the system? Well, we're going to see. You know, the photo ID tool actually kind of works. Individuals are going to be allowed to lock their SSNs. Nice, nice. They're going to lock your SSN. Sounds good. Requires parent or legal guardian to attest to the identity of minors. Sounds good. Allows parent to lock the SSN of their children. Good. So we're going to try and stop visa fraud, and then we're going to have some accuracy in reporting. So we're going to have some accuracy audits. Yeah. we'll see how that one works. So increased compliance penalties. As I mentioned, this is repetitious, folks. We're going to preempt state laws and ordinances. This is good. Many of the provisions in the Memorandum of Understanding are strengthened. Good. You're going to testify to your identity under the penalty of perjury. Ouch. Ouch. Designed to stop identity fraud. So the simple bottom line is, this better be the real Bernie Wolfstorff. Will the real Bernie Wolfstorff please stand up? There's going to be 25 of us. I can just see them, all with that graying beard. 25 Bernie Wolfstorffs. Hey, you know what? As long as they put their money into their Social Security account, into my Social Security account, so when I retire, I can live off all that money. Did you know, folks, that there are billions and billions of dollars in the Social Security suspension account of undocumented workers who are working under fake Social Security numbers? All that money goes into somebody else's account. Bingo! I want the money. The Claude Monet. Bernie, calm down. This stuff is not so funny, but it's serious. So, what do we have here? Fines, penalties for unlawful employment dramatically increased. Employee can pursue administrative review. And the law would also create a rebuttable presumption of unlawful hiring and good faith defense for failure to enroll in the system or verify employment eligibility. Ooh, ouch. Rebuttable presumption of unlawful hiring. You've got to get this together. You can't avoid this. De minimis technical liabilities can be corrected, so we're kind of okay on that. Okay, so now the anti-discrimination provisions. I'm going to make this really fast. I should be at the end, but I'm not, so we're going to have to keep the I-9 stuff for the next time. Current law prohibits immigration-related discrimination. Bernie, I need to see your green card. You've got a funny accent. Bingo, we got you. The bottom line is that these same types of discrimination based on citizenship status and national origin are going to exist, but there's also going to be additional protection for people who qualify as registered provisional immigrants, currently known as undocumented aliens. Those guys are going to be protected too. Penalize an employer for national origin citizen status discrimination arising in the hiring of individuals for employment or the employment eligibility verification or relating to compensation, terms, conditions, privileges of employment. Hey, or constructive discharge. You're going to fire somebody because they were undocumented. You know what? We're going to have lawsuits, folks. Here we go. The employer's getting squeezed again. We can just see it. Lots and lots of lawsuits. The labor lawyers are going to be busy. Almost as busy as the immigration lawyers. Ha, ha, ha. Stop that silly laugh, Bernie. That's not at all funny. Okay, so the simple bottom line is you cannot use E-Verify as a selective screening tool. Fines, massive fines. I've already explained those to you. Oh, this one is kind of silly. Person engaged in foreign labor contract activities is going to be extensively regulated. This is the labor recruiters. We're not exactly sure who's going to be covered under this, but we do know that there's fines of between $10,000 and $25,000. So, if you're a foreign labor contractor, not quite sure what that is, but it's pretty broad. Look at it. Recruiting, soliciting, hiring, employment, sponsoring, managing, furnishing, processing visa applications, transporting, housing, da-da-da-da. People who reside outside of the United States in furtherance of employment in the U.S. I don't know what this is, guys. Is that me? Am I a foreign labor contractor? Am I assisting people with processing visa applications? Are you a foreign labor contractor? We don't know. This provision is too broad. I don't like it. And we're going to be subject. We're going to register with the U.S. Department of Labor. We're all going to go register with the Department of Labor. Hey, yeah. So, folks, here's the H&L categories. Increased authority in the Department of Labor over H-1B investigations. Like they don't have enough authority right now. They have lots of authority. And they also have authority to investigate L-1 visa violations. Folks, Department of Labor, wage and hour investigations, tough stuff. Get used to it. I've just finished DOL audits. It's only taken about, how long did this one take? The offenses happened in 05, 06. charges investigation opened in 2007. We're in 2013. I think it's about 6 or 7 years now that case has been going on with the investigation. I think we're close to wrapping it up, but my gosh, 7 years of investigation, folks, on a single case where the employer honestly didn't do anything wrong. They just used one of those labor contractors. In addition, prevailing wage rates and government filing fees would be substantially increased. They are trying to use the H-1B program to lift up wages. That's what's going to happen. Lift up wages. Penalties including debarment for sponsoring non-immigrant workers. Debarment. So you do the wrong thing, you hire a bad lawyer, you're barred from sponsoring for 3 years. Folks, I'm not going to go into all the details on this. I will post my PowerPoint at some point. I do need to clean it up because we finished it at 5 o'clock this morning. Increased obligations, penalties. By 2016, employers with 50 or more, employers that employ 50% or more, face even higher fines, higher charges, elevated charges. And this is basically to stop reliance on H-1B and L-1 workers. They want to create U.S. workers, and they can even be prohibited. So this is the new dependency. This is the way to go after what we call the Indian outsourcing companies. We are going to squash the Indian outsourcing companies. They're doing such a great job helping our tech companies be in the front line. But what we're going to do is we're going to stop our kids from playing video games, and American kids are going to do this. Folks, do you have any idea how many of our companies rely on outsourced tech companies, Indian programmers, Chinese programmers? I say Indians because, you know what, India is over 50% of current H-1Bs. And I see a lot of those cases. And we're going to prohibit them from coming in. I don't really get it. I don't understand why. But the bottom line is employers are not going to be able to rely on the Tatas of the world, the Wipros, the other big contractors that bring in people on H's and L's. Such employers may also be prohibited from placing H-1B and L-1 specialized knowledge at another employer's site. Why do we hate these guys so much? Who are we trying to protect? Corporate America, stand up and stop this ridiculous situation. Anyway, if Bessie May, as we affectionately call it, is enacted in its current form, this will dramatically change the employment-based immigration landscape. Employers must really start focusing now. Undocumented need to start paying their taxes, getting their documents together. There are huge opportunities under this wonderful law. And, oops, what happened? Was that the end of my slide? I think we've kind of had enough for today. We have a blank slide there. USCIS no longer must give employers notice of intent to investigate or of notice of an investigation if they determine doing so would hamper the investigation. Oh, wonderful. Unannounced site visits. Unannounced site visits. USCIS's favorite. This is why I've been telling people not to sign the MOU. Give us a few days. There's the Fourth Amendment out the window. No longer do we have an opportunity to get our act in order. Basically, they go in, they seize your records, and you're finished. Annual compliance audits of employers with 100 or more regulation, more audits, more supervision. Oh my gosh, this stuff drives me crazy. But it does it creates private cause of action against employers. So now we get to sue employers. This part of the stuff, you know what? It's just not cool, okay? You have 24 months now. Under the current system, you've got 12 months to bring a complaint. Under the new system, you've got 24 months for workers to bring complaints. There's probably going to be more money to be made suing employers than filing H-1Bs. Yes, it's the employer that takes the hit here. As usual, corporate America carries the burden. So why are these companies all operating offshore? Why has Google made so much money outside the United States? Why has Apple made so much money outside the United States? It's these ridiculous laws that constantly punish the U.S. employer. Why do we do it? I don't know. It works well with the votes, I guess. Sorry, Bernie's getting old and frustrated. So, you know, I just want to throw in there current Form I-9 that is effective May 7, 2013. Please make sure you are using this one, the new I-9 form. Folks, I'm looking at the time. We are currently out of time. I have not encouraged you to ask questions, but I'm going to go and open up my chat column. We're going to now do another show probably in a month or so. Subscribe to my newsletter. I hope you've enjoyed today some of the sound bites. I apologize where I'm not 100% familiar with the law. This thing has been changing non-stop. Honestly, was working till 5 o'clock this morning finishing this PowerPoint and trying to incorporate all the amendments. So let's go straight to questions. There we are. How do you ask questions? Press your chat column. Do we have questions? Do we have questions? Do we have questions? Question 1, there's some questions there. Okay. Whoa, yay. We have a lot of questions here today, folks. A lot of questions. I've got a lot. I'm going to shoot over them. Can STEM category people apply for green card directly? Unclear. Does a STEM employee need to be working in a position that requires a minimum of a master's degree to benefit? Almost certainly. I mean, the idea that you have a STEM employee who's working as, it's always, is the job a STEM job and is the person working in a STEM job? Can we download the slides? Yes. Once I have them fixed, we'll be providing the slides. Enjoy, everybody. W visa is for non-agricultural, correct? Skilled and unskilled. The W visa is for non-agriculture. We have to see what gets published. So, you know, the bottom line is the W visa is skilled and unskilled. The simple situation with regard to the W visa, and this is a very perfunctory review, is replacing the H-2B program. The H-2B program has H-2A, which is agriculture, and H-2B, which is other. We will see where this ends up. It's a little bit early. Sorry, somebody came in late. They've left. Will the E categories be compatible with adjustment of status, or will it remain incompatible? Well, there is talk in some of the provisions that will allow some of the E's to apply for adjustment, like the E2, but subject to conditions, like they have 5 employees and they've invested at least $250,000. Oh, I like this one. Delightful presentation. Thank you very much. Positive comments are welcomed. And I'll try and skip through the negative ones. Actually, we don't have anyone. E-Verify doesn't currently require employers to verify existing employees. Will this change? Yes, it will change for certain categories, infrastructure employees. I'm not seeing your webinars. Well, I don't know what to say. The webinars are there. They're on our website, www.wolfstorff.com. Thank you so much for your sense of humor. That's very sweet of you. It is frustrating for employees. Yep. Thanks for the wonderful presentation. Would the H-1B increase come into effect starting from this season? You know, I'm not sure. Usually, let's hope that coming this season, April, that the new H-1 quota would in fact come into effect. Is the verification 3 days after expiration date a new requirement? Is the re-verification 3 days after a new requirement? Yes. At the moment, you have to re-verify before the work authorization expires. So you have to have a calendar system. When will the point-based merit visa separation? You know, as soon as enacted, as far as I can see. Thanks. I like that comment. Lovely presentation. Just spent 1 semester of law working in Cape Town, of law school working in Cape Town. Cape Town is one of the most beautiful cities in the world, and I'm not from there. Does the E3 visa application apply to Canadians? No. But what we do have is a TN1. So Canadians have something very similar to the E3. They have the TN1, as do Mexican nationals. And the bottom line is that these are work visa sponsored. Some of the Canadian TN categories allow for 2-year degrees, not too many. There's a few. Most of the Canadian TNs require a 4-year degree. Did I understand the new compliance regulation that employers are prohibited from allowing H-1B professionals with specialized knowledge at working at another site? You know, no, not per se prohibited, but remember the roving employee situation that we currently have is very restrictive. You have to put up posting notices, you have to have LCAs, you know, that's a 3-hour presentation for the roving employee, but there are restrictions aimed at stopping outsourcing. This bill is designed to make life miserable for third-party placement H-1Bs. That's wrong, but that's the way it is. Did that pertain to a separate employer, or does it pertain to working for the same organization but transferring to a different location? I hope that made sense. No, Brian, sorry, I shouldn't give you a name. I'm not smart enough to fully understand that. Complicated question, but the roving employee is a big one. You haven't lost your touch after all these years. Wow. Brilliant as ever. Yes, compliments are absolutely lovely. Thank you so much. You know, try and be a little bit amusing here, try and be a little bit silly, but obviously covering very, very important stuff. Can recent graduates who are on F1 apply for permanent resident permit according to the new bill? Yes, I actually think for the first time, you know, we have F1, 12 months, F1 STEM extension, 17 months, potentially with cap gap closing another 6 months. That's 35 months. Can you jump straight from an F1 to a green card? You betcha. Sorry, I shouldn't do, you know, accents, but you betcha. People with F1 OPT status, F1 on F1, all good. I'm going to take a last question just because I love answering all the questions, but I know some of you. Okay, last 2 questions. Can someone with an LLM in the U.S. apply for a TN as a Canadian citizen? Is a bar license from the U.S. necessary? Look, if you look at the NAFTA list, just Google NAFTA professional TN1 list. Number 1, you need to have a job offer. It states law degree or provisional or state license. It's a tough one. Email me offline. We'll talk a little bit more about what the requirements are, but generally you need to have a job offer. Having an LLM alone from Canada is not going to just qualify you. I'm an agricultural economics graduate. Good. And the question is, sorry, that was a little bit facetious. Yeah, is your question, are you going to be a STEM? We don't know. Are you going to benefit? Master's degree, agricultural economics? That's a big debate as to who is actually going to be included in the STEM. There's going to be a lot of lobbying for that. Can you go from a J1 to a green card? Well, yes, you can go from a J1 to a green card, but are you subject to the 2-year home residence requirement? Look at your DS 2019, bottom left-hand corner, look at your visa, see if you need a waiver. As an academic scholar, can you change from J1 to green card? Yes, provided you don't have 2 years foreign residence requirement, provided you meet eligibility under one of these categories. So STEM does not apply for me. Can I apply using non-document? Oh, thank you for clarifying. So STEM does not apply for me. Can I apply? Yeah, you don't have to be a STEM. You do not have to be a STEM, and you are a master's degree. Look, you know what? With a master's degree in agricultural economics, please email me offline. Love to have the case if you've got an employer who's ready to go. Folks, it's been absolutely wonderful. We're out of questions. We've answered every question. It's just been a joy speaking with you today. We've had a wonderful sign up. We had over 200 people sign up. And until next time, please join me. Thank you so much. And until our next webinar, the Wolfstorf webinar, which will probably be in a few weeks. Please, please, please join us and enjoy. Thank you so much and have a wonderful rest of the day. Goodbye.